is the only argument that we're going to hear this morning on this case. I'm gathering you don't want to wait or reserve any time for rebuttal
We'll be all right with that one.
to rebut against yourself. I'm keeping the clock though, so I'll keep you apprised of the time. We've read the briefs, we're ready to proceed when you are.
Thank you, Your Honor. Attorney Greg Price for Mr. Harris, Judge Callahan, good to see you. And I wish I could have something a little bit more exciting for you this morning.
We'll work it with that.
I was going to say, I'm sure she'll get plenty.
Hopefully it won't become exciting. I think that could be a problem as well. But whenever we're dealing with just speedy trial issues on all three of these cases. These are three combined cases. Mr. Harris was arrested originally on the forgery charges, a couple forgery charges. Throughout the course of the investigation, I think a couple weeks later, more forgery charges come in. More investigation, more charges come in for the exact same scheme that he was perpetuating to begin with. The issue is pretty clear, Your Honor. It's going to be a de novo review, and you can simply run through the record and do the math. I specifically outlined the continuances and the time that I thought in my brief for each individual case. I think...
Can I interrupt you?
Yes.
Okay. First of all, I don't know, a couple weeks ago I had a cold, so it seems like my hearing is still not returned quite well, so I just asked you to speak up just a little bit.
And I saw you leaning in, so I apologize for that.
No, it's not you, it's probably me. It usually is me. But at any rate, question I have for you, he pled guilty.
Correct.
How do we even look at this?
I think you have to look at this because the objections were made, the arguments were made. Whenever the court says, look, I can't see that. I don't agree with you with that. At that point, I think you can plead guilty. It's not like an evidentiary issue, where the evidentiary issue, if you have a suppression hearing, that suppression hearing, I think this court has held, is not a final order, because you still have to get to the trial, and at trial, you still have to object. Because if you fail to object at the trial court, you still waive that evidentiary issue. That's not what we have here.
No, I understand that, but I guess when you plead guilty, you waive all that.
I don't think you do.
Okay.
And that goes with my argument, because,
The case law says you do.
and I apologize if that's the case, but I would say
Okay.
that that's not the case, because whenever you're dealing with evidentiary issues, like I was explaining, you have to re-raise those. With this one, I don't think you should have to do that. If you say, look, this time is told and we're done, and that's it. It doesn't go to whether or not this person did it or not. And I haven't seen case law to that effect, and if the court has, I apologize for wasting everybody's time.
I'm not wasting anybody's time. That's why you're here. That's why I'm asking these questions.
And what I would argue with that point is, if you have an evidentiary issue that proves you're guilty or not guilty, and I say guilty, well then who cares if it proves you're guilty or not guilty? This has nothing to do with whether you're guilty or not. This is just whether or not the state has brought you to trial in a certain amount of time. And we said, no, you haven't. We objected at every step. We objected every time we needed to. And it was very clear that I even told the court, look, I'm not going to file my motion right now, because once I file my motion, that's going to toll time. So whenever we come to trial, I made it clear to everybody that whenever we get to the trial date, there's going to be a motion, and this is what's going to happen, just so I didn't waste everybody's time. Whenever it comes to reviewing this, I think the interesting point, it is de novo, but at the same time, whenever the defense makes a prima facie case that this is in fact beyond the time, the burden shifts to the state. And I think that's where the court needs to really focus on this one. Because whenever I filed the motion, whenever I put in my brief for this court, it's a carbon copy of the brief that I put in the trial court. All the times were laid out, all the continuances were laid out, my calculations were laid out. And that clearly was a prima facie case that shifted the burden to the state. Whenever the state got up to argue, the state said, we've analyzed this and we don't think we're out of time. And that was it. If you're going to say that the burden is on the state, and that's all the evidence the state has to present, there's no way that the court could have found that this was not beyond time. So whenever the courts say that this is a de novo review, I kind of have to question whether or not this court should just be doing its own independent analysis, which is traditionally what a de novo review is, or whether or not you should just be doing a de novo review of the evidence and the argument that the state made whenever the burden shifted to the state. And I know that kind of gets convoluted at a certain point. But if you look at the evidence and the arguments that the state made to support a finding that they were well within their time, there is none. The state simply pulled out their file and said, look, I got 2 or 3 continuances. I think we're well within our time, Your Honor. And
When I look at the record, will I find a reason for the last trial
glad you brought it up.
Okay.
You nailed it. Whenever that burden shifted, and I presented my prima facie case, and I lost, I presented the record and the transcripts that supported my position, that I presented a prima facie case. So you'll see the time that I filed it, the trial date when we showed up, and we finally had the sentencing where he pled guilty, and the arguments that we made. Whenever it shifted back to the state, my argument was that as it goes back to the record and the transcripts that were presented to the court, I would argue the state has an obligation to then present transcripts to support their position. And there is a time where a trial is set, and he's just never brought over. That's it. So it has to be reset. Now, there's actually 2 trial dates. The first was set with the first counsel. I was second counsel. I was appointed in September. The state hasn't asked for any of those transcripts, and they haven't asked for any explanation for those. That's where that explanation is. That explanation is absolutely in those transcripts, and it's very clear. But the state hasn't asked for those transcripts and can't, I think, bring that in front of the court because it's not outlined, I think, in any court orders. I think it's just in those transcripts.
And you're suggesting then if we looked at that journal entry, which is a record, that there's no verbiage explaining it there?
I don't think there is, Your Honor. And I still think that even if you go back to that order and you see an order that says this trial date is continued and it's continued to X, it doesn't outline the entire conversation we had on the record about why this is, what's going on, and what the court's going to do to remedy it. Because part of our argument is, you know what, that continuance, if you're going back and you're going to continue this out 2.5 weeks, and I think that continuance was almost for a month for that trial date, you have to put on the record why that would be reasonable. And again, it goes back to whenever we make that prima facie case, the burden shifts over to the state, and the state has to prove all these numbers, but they also have to prove the reasonableness of the continuances. We're not going to stand up here and argue that a 2-week continuance at the beginning of the case is while you're going over discovery is unreasonable. But whenever you start talking about 6 weeks, 8 weeks for trials, whenever he's arrested again in December, he's not brought to trial until February. This is when the case is already almost 6 months old. If you're going by a docket that is based on time, there's no way he wouldn't be at the top of any list, and there's no way he couldn't go to trial next week. All that has to be put out in an order by the court so you can evaluate the reasonableness. And I don't think any of that's in the record, and I think that's on an obligation of the state to present those transcripts to clarify how reasonable those are. So whenever I go back to my de novo argument that I was making before, whether you should just be looking at the record in total, or you should be looking specifically at the arguments the state made. And I think that's where I am. If you find that I made a prima facie case, you should do a de novo review of the evidence the state provided, which is very little. And they also supported it, but very little from the trial courts as regards to transcripts or explanations and orders for this appeal. So what I don't want the court to do is to come out with an order saying, well, Mr. Price, it might have been that this trial was continued, but we don't know why, because you didn't supply us a transcript. My argument is that that's not me. The state has to supply that transcript. It's their burden at that point. Even though they won, it is their burden to show this court that continuance is reasonable. And if they can't do that, then they could not have carried their burden at that point. And if there aren't any other questions, that's